Good afternoon, Counsel. I'm just waiting for Mr. Blumberg to join in. So if you can just remain on the line and we'll get started here in just a minute.
Will do.
Okay, thank you. Okay, excuse me, we'll go on the record now in Drudy versus Drudy. This is file number 2520064. If I could have counsel put your appearances on, starting with plaintiff, please.
Sure, Judge. Thank you. Elliot Blumberg on behalf of the plaintiff.
Susan Preckety on behalf of the defendant.
All right, thank you. We're on the record today. I think this is our first conference in this case. And just to set some dates for going forward, Mr. Blumberg, on behalf of plaintiff, can you tell me where kind of things are at and what you would like to see going forward for scheduling?
Sure, Judge. The major asset of this marriage is the marital home up here in northern Michigan. Excuse me. We're in the process of getting that appraised. Once we have that done, I think we'll be able to determine the equity and come to a resolution on most of the issues. I think 90 days initially would probably be fine for discovery. And if we need to extend that, we could probably, if you would allow us to do so by stipulation.
Okay, thank you. Counsel, do you have any objection to that?
No objection at all. We've talked, and once we get the real estate appraised, I'm sure that we'll be able to get the matter resolved.
Okay, so I'm just going to leave it open then for 90 days for discovery. I'm not going to order mediation at this point. And then I'll set it for a status conference at that 90-day mark. If it looks like the parties haven't been able to reach agreement, then we can talk about mediation at that point. If we have an agreement, we can use that date to enter proofs.
Okay.
Sounds good.
Sounds good.
Any other dates I can address for either of you here today?
I
don't think so, Judge.
Okay, so I'll send out the date for that next status conference, as well as an order indicating what we've discussed today, and you're both free to disconnect. Thank you.
Thank you.
Bye-bye.
Bye.
We're a little ahead of time, but I'm going to call the case of Berry versus Alexander, file number 2419739. That was a motion to, motion regarding the violation of a personal protection order or lead violation. The courts received notification that the petitioner in that case has passed away. Therefore, there's no need for that hearing. The respondent was notified that she did not need to appear today by the court after she called to inquire. And the court will issue orders dismissing the violation as well as terminating the PPO. Next hearing set for 2 p.m. Okay, we have counsel connected, so we'll go on the record in Patricia Johnson versus Trillium Companies, file number 2419593. If I could have counsel both put your appearances on.
Good afternoon, Your Honor. Mark Connolly on behalf of the plaintiff, Ms. Johnson.
Good afternoon, Judge Mark Mueller here on behalf of defendant Trillium.
All right, thank you. This is set as a status conference today. I think the last time we met may have been back in March. Some dates were extended. So Mr. Connolly, on behalf of plaintiff, can you tell me where things are at and what we need to do going forward here to get this matter resolved?
Yes, Your Honor. So I'm not sure if the court had the update. We did mediate this case. It was unsuccessful. We did continue to conduct some discovery, and despite efforts to try to resolve the case, we haven't. So I think at this point, we do just need to set it for a trial.
Okay, Mr. Mueller?
Yeah, Your Honor, I think there's a few loose ends that need to be tidied up, possibly. We've provided plaintiff's counsel with an affidavit, albeit unsigned, from one of the doctors, and I was hoping that was going to help push this toward a resolution. Obviously, it did not. I don't know, Mark, if you think conducting a formal settlement conference will have any difference with your client.
I would like to hope that it would, but I certainly wouldn't hold my breath on that. She is pretty hard set on letting a jury hear her case. But you know, if you want to, Judge, if you want to set like a motion deadline, you know, somewhat soon, I mean, that could possibly resolve this case too. I am open to it. Whether it will be fruitful, I do not know.
Okay. Based on what I'm hearing and the fact that the parties already, you know, went through a facilitated mediation in this case, my inclination would be to simply get this set on the court's trial docket. I agree with the proposition of setting some motion cutoff dates, so that to the extent there are any dispositive or other motions, the parties have a cutoff date to get those filed and heard. And then go from there. I did see, and I know Mr. Connolly just mentioned that, I did see there's demand for a jury trial, so the court would set this for a jury trial. And let's say if we set aside, if we give this a 90-day deadline for any kind of motions, whether that's, again, dispositive motions in limine and so forth, set a 90-day deadline to have those filed and heard so that those issues are resolved. After that period of time, Mr. Connolly, how much more time would you need after that to be prepared for trial?
6 weeks. I mean,
Okay.
nothing crazy. I mean, this has been pending for some time. I know the case well. It's not going to be, you know, experts everywhere and things like that. So, you know, it would just be getting the time for doctors to be able to testify. There's only a couple. So, you know, 6 8 weeks, I wouldn't think would be more time after 90 days.
And then how many days do you think you'd need for your side of the case?
2 to be safe. Yeah.
All right. So Mr. Mueller, if we set this for a 90-day motion cutoff and then trial at about 5 months, is that enough time for you to be ready?
Yes, Your Honor.
And then how many days do you think you'd need for your side?
I would say 1.5. So you might want to err on the side of caution and set it for 4.
Okay. All right. So I'm going to set this for a 4-day jury trial at about 5 months out. We'll set this for a motion cutoff at 90 days. And then again, that's filed and heard. And then I will set this for, I call it a trial preparation conference, but about a month prior to the trial date, where we can get together, talk about just, you know, exchange of final witness and exhibit lists, composition of the jury, how many jurors to seat, how many will constitute a verdict. To the extent that either side, we could talk about stipulation, if we have any exhibits that can be stipulated to and submitted to the court ahead of time. All those kind of things we can talk about at that trial prep conference. So I'll set that as well. That would be the next date. If neither side files any motions, then the next date would be that conference immediately, 30 days prior to the trial dates. Mr. Connolly, is there anything else that you want to request in terms of dates today?
No, Your Honor, I think that that's appropriate.
Okay. Mr. Mueller?
No, thank you, Judge.
Okay, so what the court will send out is the trial dates, the notice of the date and time of the trial prep conference about 30 days prior to the trial. And again, the only other hearings we would have prior to that would be to the extent that either side files any motions within that 90-day period and sets them for hearing. And then I'll put out a scheduling conference order based on what we said here today. And that's all I have. And you're both free to disconnect. Thank you.
Okay,
Thanks, Judge.
Thanks, Mark.
Thanks, Mark.
Scott Norton.
Okay, Mr. Norton, can you hear me all right?
I can hear you fine, Judge Mertz.
Okay, great. Mr. Fico, can you hear me?
Good afternoon, yes.
Okay, we're on the record now in TBF Financial versus 45 Degree, case number 2319505. If I could just have counsel put your appearances on real quick, thank you.
Thank you. Good afternoon, Daniel J. Fico, P 58733 on behalf of plaintiff TBF Financial LLC.
Scott Norton on behalf of the defendants 45 Degree Hospitality, Inc. and Dean Bach, P number 35717.
Okay, thank you. We're on the record today. This is a final status conference. It looks like we have a trial date set for August 1st. Mr. Fico, are we ready to go from your standpoint?
I believe plaintiff is ready, Your Honor. I've had some discussions recently with Mr. Norton. We are working diligently to try to pull off some kind of a last-minute settlement here. I'm hopeful, but we're not there yet.
Okay, Mr. Norton?
That would be accurate. I actually, Mr. Fico reached out to me earlier on Friday, and I reached out to my client and spoke with him a little bit earlier. He's, local. This is not, I'm sorry, but it's a $30,000 case on a contract for a bench trial, which you've scheduled for Friday, August 1st. I'm looking at my calendar, correct? I want to get this resolved big time. This doesn't need your attention, but I'm working with someone that's a little tenderfoot on this, involving other issues. But having said all that, I offered I see that my opposing counsel is downstate as I am. Is there a way for us to go to binding arbitration or something? I just don't see taking up the court's time on this, and I'll agree to the loser pays, but I don't know. I don't want to get into the details of the case, of course, since you're trying it, in terms of what the documents say and what they don't say, and who's who and who's what. I'm just kind of putting that out there, Judge.
Well, I mean, I'm in the position of, my role here is to provide a forum to resolve the dispute for you guys. And I'm doing that. I've got a date set for you on August 1st. And I don't know that I can force anybody to do anything other than appear, and we go forward on that date. Obviously, you both are free to discuss those kind of options. And I would have no objection to, to the extent you can agree to some kind of alternate way to resolve this. I don't know that I would have an objection to that, but I don't think that's something that is really my role. So I'm going to leave the date on. I'm going to plan to be ready to go forward on August 1st to get this matter resolved. It's been pending for quite a while. So it's right to be over with. To the extent that either of you are able to find some other resolution, I'd be more than happy to consider that too. So that's where I'm at. So I'm not going to order anything different at this point. If we are going to go forward with trial, as it is a bench trial, it's going to make things a lot easier in terms of, how the procedure that we'll have. I just would encourage both of you, if we are going to have that trial, to the extent that you need to use, any kind of video or, present exhibits electronically and so forth, that you contact the clerk's office and make arrangements so we're kind of limited in terms of what technology is available here in the courtroom. To the extent that either of you are going to call witnesses remotely, I certainly don't have an objection to that. If there's an agreement of the parties, that's fine. But to the extent that there isn't an agreement, under the court rules, the court has to consider certain things, and I think we would have to have a motion if there isn't an agreement for witnesses to appear remotely.
Your Honor, before I spoke with opposing counsel, if I may speak, I'm sorry to interrupt. I looked at I didn't see your protocol for a bench trial. So exchanging exhibits and listing witnesses, that kind of thing. Leave that to the two of us, so to speak.
In bench trials, generally, I find that that's not an issue. So yeah.
Okay. So you don't require like a trial brief or anything like that?
In some cases I do. This case, we've had enough motion practice. I'm aware of the issues here. It's been pending for a while. I don't think I need trial briefs. So really it would just be up to the two of you to have your witnesses ready to go. I understand what the issues are, and put your evidence and witnesses on, and the court will make a decision.
Understood. Well said. Okay, I just wanted to ferret that out a little bit.
Sure.
But as for Mr. Fico, again, if you wanted to alternative dispute resolution, we're acceptable to that.
Well, I agree with Judge. This is the forum that is the purpose of the court system. We've already invested a considerable amount of effort in bringing this case to this point. So I would certainly, I will certainly continue to engage in efforts to try to reach a settlement here. I don't believe any kind of alternative forum is necessary or even appropriate here.
Understood. So other than that, game on for Friday, August 1st, 9:00 a.m. Friday.
Correct. So what I will order is, and this will go out in writing to both of you. What I will order is that the parties exchange witness and exhibit lists at least 14 days prior to the trial date, and that's, final witness and exhibit list. So witnesses that you actually expect to call, and exchange those 14 days prior to the trial date, and also provide those to the court. So I have an idea of how many witnesses each side is calling. Again, I don't need trial briefs in this case, based on the issues. I'm familiar with that. So as long as both sides have disclosed their witness and exhibits, I would encourage you, I'm not going to order it, but I would encourage you both, to the extent that you can confer and agree on any stipulated exhibits. That just makes things go faster on the day of trial.
Understand.
But, I don't think there's going to be a whole lot in terms of paper exhibits in this case.
Your
So-
Honor, if I may interrupt, how do you conduct your courtroom on a normal bench trial day, like say Friday? Do you start at 9 and then go to X? And
Right,
break?
the notice, and it's probably already been sent out, but I believe it has parties directed to be present by 9 a.m.
Right.
Start at 9. Yep, 9 a.m. And then, full day until we're done.
You don't have a standard time that you break for lunch or anything? I'm just
No, I
trying.
just try to find a good break in testimony wherever there's a good natural break.
Understood.
And
Understood.
in a bench trial, maybe 45 minutes, an hour at most for lunch, and then we'll keep going.
Okay.
Okay, thank you. That's all I have for today, and you're both free to disconnect.
Very good. Thank you, Judge.
right, we have both counsel connected, so we'll go on the record in Haskell versus Haskell. This is file number 2218880. If I could have you both put on your appearances, please.
Zach Backlund on behalf of the plaintiff in this matter, Aubrey Haskell, who's appearing by Zoom.
Good afternoon again, Judge Elliott Blumberg on behalf of the defendant, David Haskell, who's appearing from my office via Zoom.
Okay, this is set, this is a status conference today. Mr. Backlund, can you give me an update on where we're at with this file?
Sure. Last time we were in court, Your Honor, it was regarding defendant's motion to modify the spousal support, and we were dealing with issues related to potential credit for knocking off of the arrears. Prior to being able to complete that, we are waiting on the child support recommendation, or in effect for the order to come into place. I believe that the recommendation was mailed out last week or very recently. I haven't received it yet, but I saw on the online docket that that has been created. Certainly, I think the understanding was that we were waiting for that to become an order without a chance to review it yet. I know there have been objections to those in the past. Hopefully this one gets through. So the update is that there isn't really anything that we've been able to achieve since we haven't received that recommendation.
Okay, Ms. Kraus, did you want to provide any additional information there?
Just indicating, in fact, that that new support recommendation did go out in the mail on July 1st.
Okay.
All right, thank you. Mr. Blumberg?
Judge, I think that it's worth noting that every recommendation of support that's been made has been objected to. We have received the most recent one, and I suspect it will be the basis for another objection. So the child support remains an issue. The house and the repairs and all the work that needs to be done, I think where we left it was that Mrs. Haskell was going to contact contractors to come out and determine how much it was going to cost to complete the repairs that were required. I think the court's order required the parties to share in the cost of that. My client is to pay for all the materials. So that property related issue, I think, is almost resolved. I don't believe we've come to an agreement on the spousal support credits. That remains out there. That was a rather painstaking procedure to provide all the bank records reflecting the payments that were made. So in terms of the status of the case, regrettably, we're not quite there yet.
Okay, so I guess what I would suggest is setting this for another hearing following the expiration of the objection period for the latest recommendation. Do you have an objection to that, Mr. Backlund?
No objection to that. I think that makes sense, Your Honor.
All right, Mr. Blumberg?
No, that's fine.
Okay, so the court will send out notice of that hearing and we'll go forward from there. Mr. Backlund, is there anything else I can address for your side here today?
Nothing further. Thank you.
Mr. Blumberg?
No, Judge, thank you.
Okay, that's all for today. Thank you. All parties on this file are free to disconnect at this time.
Thank you.
Mr. Majestic, which case are you signing in on?
Northern Mutual versus Prather, Your Honor.
Oh. All right, got Mr. Couch.
Good afternoon.
All right, is this the Prathers on the phone?
Yes, yes, Your Honor. I'm sorry. We have a storm here, and it just knocked me out of the meeting on the Zoom. But I called the court, and she gave me this phone number to add.
Oh, okay.
Okay. So I'm going to try to get back on, but I'm here.
Okay, if I see you in the waiting room, I'll bring you in that way as well.
Thank you.
And then just let me know if you're having any trouble hearing what's going on, okay?
Okay. Thank you very much. Thank you.
Sure. All right. So let me bring in, we got a couple other people signing in here.
Okay.
Okay, so I think we've got everybody connected. I'd like to address, because we have both files set at the same time here, but I'd like to address the Northern Mutual versus Prather file first. That's file number 2419867. If I can have the counsel on that file, put your appearances on, please.
Casey Majestic on behalf of the plaintiff, Northern Mutual Insurance Company.
Kevin Riemann in pro per.
And then Ms. Prather is present here by phone. They've had some connection difficulties due to weather, but she is present by phone. This is set for, it looks like Mr. Majestic, you're asking to have the file dismissed. Is that correct?
Your Honor, there have been some updates since I filed the motion to dismiss without prejudice. We've reached settlement agreements with both Mr. Riemann and with the Prathers. The Prathers, however, aren't willing to sign stipulations and orders to dismiss the cases with prejudice. This morning, they had forwarded me stipulations and order to dismiss that they had signed, but they had attached long affidavits that were inappropriate and said they were part of the signature, so I don't feel I can file those stipulations and orders as they are. Mr. Ryman had previously signed those, but I can't attach another document and represent that he had signed off on that, Your Honor. We had asked for a dismissal with prejudice based on the release, but I would like Ms. Prather to confirm that we have a settlement on the record before we do so. It's a confidential settlement, so I don't want to go into the terms of the settlement, but I would like her to confirm that we do.
All right, Ms. Prather, were you able to hear that?
Yes, Your Honor. I did sign the stipulations. I did want to add the affidavit. It's not a long one. I'm not sure why he says it's inappropriate because I'm not asking for any change. All that I want is it to be on record. However, I'm not an attorney. I did not choose not to have an attorney. We just simply can't afford these legal fees, Your Honor. And I will sign the stipulation how you'd like, but could I just please say something for the record?
As long as you're not going to discuss the terms of the settlement, sure.
No, not at all. No, it's not. Okay. I just would like to say that my husband and I have agreed to the settlement and stipulation to dismiss the cases, but I just wanted to make it clear that we did have strong documented evidence, permits, emails, and photos that fully disprove the claims against us. Unfortunately, the court never had the chance to review that evidence, so we chose to settle only to end the long stress of almost 2 years and cost of defending ourselves against not only the claims against us, but its joinder with unrelated defendants. This process has caused great hardship. I also believe that Mr. Ryman has shown a pattern of using the courts in ways that harm others. And I say this not to argue the case, but to just ensure our experience is part of the record. I thank you for letting me speak.
Okay. All right. With that then, Mr. Majestic, are you satisfied that there is an agreement to settle the case?
I am, Your Honor, and we were asking for a dismissal with prejudice and without costs as to either of the defendants.
Okay. So, and did you submit a proposed order already on that?
I did not, Your Honor. We did not have a settlement with the Prathers at the time I filed the motion, so the proposed order would read without prejudice rather than with prejudice. However, one slip of the pen would change that to with prejudice.
Okay, so I'll sign that once that's been presented. If you can submit that under the 7-day rule, please.
Thank you, Your Honor.
Right. Mr. Majestic, is there anything else that you need to address on that file?
I don't believe so, Your Honor, although I'm not a part of the underlying case that Mr. Ryman had filed. It's the same situation in that case as well.
Mr. Ryman, on this file, is there anything further that you needed to address?
No, Your Honor.
Okay.
Your Honor?
Yeah.
I'm sorry. Okay. Would I be able to submit that affidavit or no?
That's not really going to be part of the court file. And, you know, I appreciate that you want to make it a statement for the record, and I've allowed you to do that. But that's from a standpoint of the legal pleadings, I think Mr. Majestic's correct. It's not something that, it's really your own personal commentary. And that's not really something that belongs in the pleadings. So.
Okay, thank you.
Okay. So that addresses that file. The court will consider that Northern Mutual versus Prather and Freeman is now closed, pending, of course, the signing of that final order. So now we'll move on to Freeman versus Johnston and Prather, and that is file number 2319394. We have a similar motion from Mr. Riemann in that case to dismiss the Prathers. Mr. Riemann, anything that you wanted to state for the record on that? So you're muted, Mr. Riemann.
Thank you, Judge. I have a bit of a cough this morning, so I don't want to bother everybody with it. But I don't have anything further to say in light of Mr. Casey's acknowledgement that the Prathers have agreed to that dismissal.
All right, Mr. Couch.
Your Honor, I have no position with regard to the claim by Mr. Riemann against the Prathers.
Ms. Prather, is there anything you wanted to say with regard to that matter?
No, it's the same. And I guess they heard my statement, correct?
Yes.
Mr. Couch, okay, that's so I guess it's the same in regards to that. Yeah, it's the same as we settled, I guess, and just want it on record. Thank you.
Okay. All right, so the court, Mr. Riemann, for the record, the court assigned that order dismissing the Prathers. So Ms. Prather, you're no longer part of that case. You're more than welcome to remain on the line if you'd like to hear the remainder of the proceedings.
Okay,
but that's
yes,
up
I
to
would.
you.
Yeah, thank you. I would, thank you.
I'll be logging off, Your Honor. Thank you very much.
Thank you.
Thanks,
And then
thanks, Casey.
what we have left then in that file today, there was an order that was submitted under the 7-day rule resulting from the motions at the last hearing submitted by Mr. Couch. Mr. Riemann objected to some of the verbiage in that order and submitted his own proposed order. So Mr. Riemann, I had a chance to review all that. Anything you wanted to state for the record?
Just briefly, Your Honor, because to my knowledge, there was no response opposing my objection filed. So I assume maybe we're all in agreement on it. But as to Mr. Couch's order, he did not express clearly that the judge had granted summary disposition to plaintiff with regard to the zoning violations of the rope fence. So I think my order, the first paragraph clearly states that, and the reasons for it that the court stated on the record. The second part of my objection is the way that Mr. Couch stated the court's finding with respect to the rope fence would have precluded a finding of negligence, which is not consistent with the court's ruling. The court's ruling found that it was a zoning violation, and so that at least is evidence of, excuse me, a per se negligence. So my second paragraph just simply says what the court said. You found that there was no evidence that the rope fence was constructed as a incident of trespassing, and you dismissed the trespassing claim. And that's clearly stated in my order in the second paragraph. The third issue I took with Mr. Couch's order is that he expressed commentary about what damages are permitted. And there certainly was a discussion of the court. And I had noted to the court that I wasn't prepared to discuss the issue of damages, whether it be consequential or direct or economic or indirect or non-economic, because Mr. Couch had not raised that issue in his motion. And I cited in my objection the part of the court rule that says he has to specifically state each issue that I have to respond to. The court did take it up, had mentioned that clearly economic damages would be allowable, and wasn't sure as to non-economic is how I remember the court reading. I did try to go and take a look at the transcript that was filed, but the court or the file had already gone to you this morning, so I didn't get a chance to read that. My memory is the court said, I looked at it, economics allowed, non-economic, I'm not sure. Be that as it may, there was no discussion of direct or consequential, and it certainly wasn't in the motion. So I do think that's proper and would be a good use of the court time to have that issue resolved pre-trial, but that would be something I would suggest would be more by way of motion in limine. And so I think my paragraph 3 clearly states there's a fact question presented by the evidence, and therefore the damage to the driveway claim remains. Thank you.
Thank you, Mr. Couch.
Very briefly, Your Honor, as the court probably knows, the two proposed orders are quite similar. As Mr. Riemann just pointed out, he took exception with the final paragraph or final sentence in paragraph 3 of my proposed order that indicated that the plaintiff's damages would be limited to economic damages only. I do believe that that was part of the court's ruling in the last hearing on June 2nd. And, with regard to the rope fence, I simply drafted my proposed order based on the allegations that Mr. Riemann included in his complaint, and that paragraph alleged both negligence and trespass with regard to the rope fence. So when the court granted partial summary disposition to my clients on that, that's why I included the word negligence. But again, the two proposed orders are really quite similar. I understood Mr. Riemann's main objection to be the reference to the limitation to economic damages.
Okay, thank you. All right, I did have a chance to review both orders. I did have an opportunity to look at the transcript coming out of the June 2nd hearing, and I find that really the only change, I don't have any objection to Mr. Couch's order with regard to the fence. I think it's accurate. I think it does accurately reflect the ruling of the court on the record that day. I do find, though, that as to the third paragraph, in particular the sentence that plaintiff's damages in this regard would be limited to economic damages only, having reviewed the transcript, and this is really my fault, the court should never do this, and that's just make unsolicited comments about what it thinks the law might or might not be, which is what I did. And so I did not make a finding that it would be limited to economic damages. I made a comment that I didn't think they would be available based on the the limited research I had done during the break at that time. Again, I caused my own problem in making that statement, but I do think that sentence is inaccurate and should be stricken from the order. I do agree, though, that I think that's a legal issue, what damages would and wouldn't be allowed. And so to the extent that either side wanted to raise that as an issue prior to an evidentiary hearing in this case, I think that would be appropriate, because I do think that's a legal issue that would have to be decided. But in terms of the objections, the court's denying the objections, except the objection to the statement that plaintiff's damages would be limited to economic damages only. So Mr. Couch, since most of the order is going to remain and it just requires the deletion of that one sentence, I'm just going to ask that you resubmit your order with that sentence omitted.
Thank you, Your Honor. I will do that.
Okay. And that brings us to our final issue, which is a status conference in this case, and that is, where do we go from here? Mr. Riemann, on behalf of the plaintiff, how do you want to proceed going forward?
Judge, I don't know if you, I'm not sure I understand the court's previous rulings. I don't want to just sit back and then file another objection. We didn't really address part of Mr. Couch's order regarding water damages. The water damage issue that was ruled on by the court was as to making a finding pursuant to Mr. Couch's previous motion, first motion for summary disposition, that because plaintiff didn't offer expert testimony, and they did have expert testimony that made a conclusion that the Johnstons' activities did not, I'm sorry, the Johnstons did not increase water flow onto Riemann's property. And the court accepted that and made that the ruling. Now, that didn't deal at all, and the court specifically said this doesn't deal at all with the driveway claim, the claim of damage to driveway. And just to refresh the court, Your Honor, I know it sounds like we're rehashing it, but it's a significant point. There was two main issues that I claimed. The Johnstons elevated their property and removed the drainage ditch that was installed as part of the new construction drain plan for both properties. Then there was a second one that was not part of that first motion, and that is that they changed the direction of the pitch of my driveway and reversed it so that the water, like the witnesses I provided to the court testified, if any water came onto the driveway, it flowed to the south and away from my home into a catch basin that was installed there. So even though the court ruled that I haven't proved that water flows onto my property because of what Johnstons did, there was never a discussion about a equally important issue, and that is the water that does flow onto my property. Let's say it's not the Johnstons' fault, but the whole nature of this kind of a claim is they changed the direction of the flow. So it used to go into a well, and now it goes into my house. So Mr. Couch is trying to pull a fast one. Nothing improper with that. He's doing a good job, advocating for his client, but he's trying to slip in that I can't claim as a consequence of changing the pitch of my driveway that the water that naturally flows onto my property, no fault of Johnson's, now comes into my house as opposed to going away. And the order, if you don't accept my order and you just have him strike the one sentence, it would change everything. It would now say, Mr. Riemann can't show the videos and the pictures and all the stuff of the water flowing down his driveway into his house, and he can't put in his witnesses that were submitted with both motions for summary disposition that say all the water used to go away. And I can't submit the evidence of Ms. Van Sumeren, who said she watched him, she heard him admit it, she heard him apologize to it, she saw the consequences. So that it's the whole case again in a nutshell. The court didn't rule that I can't prove what would be consequential damages of changing the driveway. And so again, I appreciate the court. I know you moved past that, but I I'm asking the court to enter my order or to have that provision struck too, that I can't prove the consequences of the change to my driveway.
Thank you, Mr. Couch.
Thank you, Your Honor. The court addressed this argument by Mr. Riemann on June 2nd. I had expressed concern at that hearing that he's trying to backdoor his water damage argument with this driveway trespass claim. The court previously very clearly ruled that the only claims that are going forward do not involve any claims of subsequent water damage to his cottage. I would ask that the court, still allow the order, as the court just indicated a moment ago, the order that I submitted to be entered.
Yeah, so I think it's, in my view, the court's been very clear all along with regard to each of the motions that's been filed, and that is it's dismissed all claims relating to water damage. What we're left with now is a claim relating to the Johnston's entry onto the driveway with their tractor and whether or not there are any damages resulting from that. The court has consistently excluded and granted motions for summary disposition with regard to any claims that anything that the Johnstons did or didn't do on their property is resulting in the water damage for the reasons I've already stated for the record, and I'm not going to go through it again. So in my view, the damages would only be related to those caused by their use of the tractor on the driveway, and damages unrelated to the water damages that have been claimed. So that's why I agree with Mr. Couch's order, and I disagree that any claim for water damages resulting from anything that the Johnstons did or didn't do still survives. I think the court's been very clear that those claims have been dismissed as part of summary disposition. So in my view, unless the parties want to set a deadline for filing a motion as to exactly what types of damages might be allowed on that remaining claim, we should set this for a hearing on the damages issue and get this resolved. So I think maybe now that we're talking about it, I am going to set a motion cutoff for 60 days as to the legal issue as to what types of damages would be allowed for trespass. And by that, I mean whether it's economic damages. At the last hearing on June 2nd, Mr. Riemann, you were claiming some non-economic damages, and that's where the court made its kind of off the cuff comments. But in my view, that's the legal issue, is whether it's economic damages or non-economic damages would be allowed for their trespass onto the driveway. So we'll allow 60 days for any motions with regard to that to be filed and heard. And then with regard to damages, how far out, Mr. Riemann, would you like the court to set that beyond that 60-day period for the evidentiary hearing as to damages? Mr. Riemann, you're muted again.
I'm sorry, Judge. I thought your first order was 60 days to file that motion.
Correct. Beyond that, how much time do you need to be ready for an evidentiary hearing as to damages?
Oh, I don't know, another 60 days, maybe after the ruling.
Okay.
And Judge, just for the record, you've said the last few. Oh,
go ahead. Go ahead, Mr. Riemann.
Yes, Judge. The last few. Thank you, Judge. The last few statements you've made have indicated that I can only move forward with damages for trespass. I understood the court's previous ruling to be that my claim that damage was caused to my driveway by the tractor intentionally, they reversed the direction of that and that's not how I wanted it, and that I am permitted to present my case of damages as to the damage caused to my driveway, not just trespassing, but physical property damage.
I mean, the remaining claim is trespass.
Well, you ruled at the last hearing, Judge, that I had proved, or at least raised the question of fact, that they intentionally damaged my driveway.
Right, by the trespass.
And trespass, yes.
No, by the trespass. That's the claim that's remaining. It's your claim. You're the one who pled it in your complaint, a claim for trespass for them entering onto your property with their tractor.
I pled that they also changed changed it, and that caused me damages.
So, Mr. Regan, you're continuing to try and get your water damage claim in when I've clearly ruled that the Johnsons are entitled to summary disposition on any claim that anything that they did or didn't do caused water damage to your property. And you're continuing to try and use the remaining claim to try and reintroduce that element of damages, which I've ruled against. So no, I'm simply not going to allow it. What's left is, did the entry of their tractor onto your property, onto your driveway, cause some type of damage to your driveway?
Okay, well, that's kind of merging the property damage and the trespass. That's fine, but just Judge, this is the first day.
That's what you pled. That's the claim that you pled, and that's the one I found is the only one that's surviving.
Okay, so Judge, just so I want to clearly state, this is the first day we've ever talked about water damage caused by the change to my driveway.
I'm not gonna keep having you're completely misrepresenting everything that's happened for the last year in this case. This is not the first time. This is the first time you're trying to shoehorn your water damage claim onto something that you, as you pled it, didn't have anything to do with water damage. So I'm sorry, and I'm not gonna argue with you. I'm not gonna argue with you. That's what remains. That's what we're gonna go forward on. So the court is gonna set this for a motion cutoff as to the legal issue as to what types of damages are allowed for trespass at 60 days. The court's going to set this for an evidentiary hearing as to damages for 60 days following that. And that's how we'll go forward. Mr. Couch, are there any other dates that you would like to request at this time?
Just a requested clarification on the deadline to file the motion. Given other matters I have on my calendar, may we have 60 days to file the motion? I thought I heard the court say 60 days to file it and have it heard. If we may have 60.
I'd like to get this issue settled. I don't think it's a complicated legal issue, really. I mean, what damages are allowed for trespass, I think, is a pretty straightforward thing. We're doing these hearings by Zoom. If you need to have some other counsel cover that argument for that motion, I'd like to get this case resolved. So
I can do it, Your Honor.
All right.
And then Your Honor also referenced an evidentiary hearing. Is that's not in lieu of a trial on his remaining claim, is it?
I think Mr. Reman's probably made a jury demand. So I think that would be a jury issue as to the damages. So yeah.
Okay. All right. Which I suppose, since we're having a pretrial conference, brings the court and the parties to the next topic of, does the court want to set this matter for trial, to hold the parties' feet to the fire and have a date out there, or?
Yeah, so I guess when I say evidentiary hearing, I mean, that's what I'm talking about is 60 days following the 60-day motion cutoff would be the date that the court would set this for a trial as to the damage issue.
Okay, all right. Your Honor, I do have a couple of other trials that I'd like to make the court aware of. Can we work with the clerk's office to schedule that trial on this case?
Yeah, if either of you want to contact Jennifer, my assistant, and let her know dates that you're not available, then we'd be more than happy to schedule around that.
Thank you. And
then the other thing that the court, just so the parties are aware, the other thing that this will be set for is on the motion day prior to the trial date, the court will set this for a final status conference where we can discuss the kind of the procedural aspects of the trial in terms of the composition of the jury, exchange of final witness and exhibit lists and so forth.
Thank you, Your Honor. Hey, in your honor, since we're discussing setting it for trial, I have to let the court know one of my clients is scheduling surgery. And it's going to be, pretty invasive surgery that will take time to recover from. Is that something that we can discuss with Jennifer when we're trying to schedule this?
Yes, absolutely.
Thank you. Good, because last time I spoke with my clients, they were going to get an update from the doctors, and I should definitely know more soon and when we speak with Jennifer. So thank you, Your Honor.
All right, Mr. Riemann, anything further from your side today?
Just, Your Honor, I'd like to state on the record again, I would ask that those hearings, I've asked for each hearing to be done, that at least I be allowed to attend in person. I think I have that right, especially at an evidentiary hearing and a summary disposition hearing. I've been told that the court's not set up to do that. I just want to make sure it's clear on the record that I've been requesting that they get set like that, and I would continue to ask that they get set like that so that I can come in person and present my case to the court.
So the jury trial certainly will be in person. The court sets all other hearings and civil cases by Zoom for the court rule. Mr. Riemann, if you want to request those to be set in person, then I'll just ask that you file a motion pursuant to the court rules on that. As far as I know, you've never filed a motion to have these hearings set in person.
I read the court rule to say that I just need to request it in writing, which I've done each time.
I don't think that's accurate, first of all. And second of all, if you want to have these hearings set, hearings that are presumptively by video conferencing technology under the court rules, you need to file a motion. So the court will set out notices, the deadlines we've discussed today. Again, Mr. Couch, I'll just ask that you submit that order as we've indicated with the change, and all parties are free to disconnect at this time.
Thank you, Your Honor. Take care, Kevin.
Yep, you too, Dave.
Thank you, Your Honor.
Thank you.
Judge, I do have an email from Wendy for the car case. Elliot had to jump into a district court case scheduled at 3. She said that he'll be back shortly. So
sounds good. Thank you.
You're welcome.
Okay, thanks for your patience. We're on the record now in Skinner versus Skinner. This is file number 2520071. If I could have counsel put your appearances on, please.
Good afternoon, Your Honor. Brooke Robinson appearing on behalf of the plaintiff, Austin Skinner, who is appearing via Zoom in my conference room and seated to my left.
Good afternoon, Your Honor. Maria Zografi on behalf of Ms. Alba Pozegu Skinner. She is present today via Zoom.
Thank you. This is set as a scheduling conference in this divorce matter today. Ms. Robinson, on behalf of plaintiff, can you kind of tell me where things are at so far and what you'd like to request for scheduling going forward?
Yes, Your Honor. Actually, we've already come to an agreement as far as property settlement. There are no children to deal with, so we have agreed on the language for it. We are drafting up the judgment right now. So honestly, as far as scheduling, we'd like to schedule our pro-con.
Okay. Ms. Zagrafi, is that correct from your standpoint?
That is my understanding, Your Honor.
Okay. Counsel, to both of you, is 30 days enough for you to get that final draft ready to go and submit it to the court?
Yes, Your Honor, it absolutely is.
Okay. All right, so we'll set this for a final hearing in about 30 days. Counsel, if you can, please submit that judgment prior to the hearing date so the court can review it and sign it during that hearing. And Ms. Robinson, anything further from your side?
No, Your Honor, thank you.
Ms. Zagrafi?
No, Your Honor, thank you.
Okay, thank you. All parties on this file are free to disconnect at this time.
Thank you. Have a great day.
Thank you. All right, Mr. Allmacher, are you there?
Yes.
Hey, I can hear you, but I can't see you. Is your camera on?
I just turned it on.
Okay. All right, we're on the record.
You see me now?
I can't, but that's fine. I can hear you good. So that's we can go forward if you're having problems with the camera. We're on the record in Allmacher versus Allmacher. This is file number 25-20018. The record should reflect that Mr. Allmacher is present today by Zoom. Mr. Allmacher, I have this set for entry of a default judgment of divorce today. Is that how you wanted to proceed?
Yes, sir.
Can you raise your right hand and let me know once it's raised?
It's raised.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. You can lower your hand. Mr. Allmacher, I'm going to ask you some questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. The first question is, you filed a complaint for divorce in this case. When you signed that complaint, had you been a resident of the state of Michigan for at least 180 days? Hello?
Yes.
Had you been a resident of the state of Michigan for at least 180 days?
Yeah. Yes, sir.
Had you been a resident of Otsego County for at least 10 days?
Yes, sir.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, sir.
Is that still true today?
Yes, it is.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
To your knowledge, is Miss Allmacher currently pregnant?
No, not to my knowledge.
Okay, you understand as part of the divorce that you will not be receiving any alimony or spousal support. You understand that you'd be waiving that forever and you could not come back later and ask the court for that.
I do understand that.
Okay. All right, and have you already divided up all the property and debts between the two of you?
Yes.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of Mr. Allmacher. I've reviewed the file. It appears that Ms. Allmacher was properly served with notice of the summons and complaint in this case, that she did not file any answer or otherwise defend. She was defaulted and provided notice of that default along with notice of the date and time of today's hearing, which was 2:45. It's now 3:15. She has not appeared to contest the divorce. So the court will grant the divorce based on the testimony of Mr. Allmacher and the default of Ms. Allmacher. And Mr. Allmacher, I've signed that judgment, so your divorce is final as of today. Do you have any questions at all?
Okay. No, sir, I really appreciate it.
Okay. All right. Thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
Okay, we'll go on the record in Carr versus Carr. This is file number 2419798. If I could just have both counsel put your appearances on, starting with plaintiff.
Good afternoon, Elliot Blumberg on behalf of the plaintiff Alma Carr, who is appearing from my office via Zoom.
Thank you, Your Honor. Jason Thompson on behalf of defendant Scott Carr, who's with me in my office. Thank you.
Okay, so we had a hearing last month, at which time Mr. Carr indicated he wanted to retain counsel, which he's obviously done. So then the court set this first status conference for today. Mr. Blumberg, on behalf of plaintiff, can you tell me where things are at as of today?
Sure, Judge. We had a judgment of divorce prepared to go forward. On Thursday or Friday, I received from Mr. Thompson an emailed copy of a motion to set aside default. Mr. Carr has been in default for a number of months now. I don't know what we can do until such time as that's noticed up for hearing and you hear the motion.
Okay, and I do see, I didn't see that earlier, but I do see that set for August 4th. Mr. Thompson, would you agree with that?
I agree. Yes, and I think we have that hearing date. I'm not 100% sure on the status of service of Mr. Blumberg based on the holiday, but we will get him that hearing notice as well.
Okay. All right. So yeah, I've got the notice of hearing as Monday, August 4th at 3 p.m. So we'll proceed with that motion. The court will reset the status conference for that same date and time, and we'll go forward from there. Mr. Blumberg, anything else I can address for your side today?
Judge, I just want to make sure I understood what you just said. So in the event that the court were to deny the motion to set aside the default, we could go forward with the entry of the judgment?
I think so. Yeah. I mean, I don't see why not. But I guess I'd have to hear argument from Mr. Thompson at that point if the court denies the motion. But yeah, I mean, I guess I'd have to see what happens. I can't tell you that right now.
Yeah, no, I get
Mr.
it.
Mr. Thompson may be able to make an argument, you know, as we're all aware, even if Mr. Carr's defaulted, the court still has an obligation to make sure that any judgment that's entered is equitable.
Sure.
So I would think Mr. Thompson didn't have the ability to make those arguments. So whether or not that judgment could be entered immediately that day, if the court denies the motion for the default to set aside the default, I don't know. I think I'd have to give Mr. Thompson an opportunity to argue that, and then I'd have to decide. So, but I think you're within your rights to request it at that time, certainly. So, yeah.
Fair enough.
All right, Mr. Thompson, anything further from your side?
Nothing further for today's record. Thank you, Your Honor.
Okay. All right, thank you. That's all on this file, and both parties are free to disconnect. All right, counsel, you're okay. I see. You're signing in on the Kurzanowski versus Lewandowski file. Is that correct?
Yes, Judge.
Okay. And that is file number 2419943. Counsel, if you can put your appearance on, please.
Kevin Callahan for plaintiff, P78273 from Levasseur Dyer and Associates.
All right, this is set as a date and time for entry of a default judgment quieting title. I did have a chance to review the motion in support of that default judgment as well as the file generally. It does appear that the defendant was properly served with the summons and complaint by alternate service following an order of the court allowing that. There has been no responsive pleadings or anyone appearing to contest. There was a notice of the date and time of today's hearing, which was 3:15. It's now 3:20. No one has appeared today to contest it. So I do think it's appropriate. Counsel, anything you wanted to say in support of your motion today?
No, Judge, we would just be asking for an order quieting title. I believe we submitted an order with our motion as well.
You did, so I will sign that order. Anything else that I can address for your side today?
Nothing further, Judge. No.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.